Here's a striking fact. Under DPDP, data principals aren't just passive recipients of protection, they carry actual legal duties too, something almost entirely absent from GDPR. Most privacy professionals trained on European frameworks are genuinely surprised the first time they encounter this. In this chapter, we shift focus from fiduciary obligations to the other side of the relationship, what data principals can demand and what they're expected to do in return. You'll learn about the right to access information, correction and erasure, grievance redressal, nomination, the duties individuals must uphold, cross-border processing rules, and the exemptions that limit the Act's reach in specific situations. Think of Chapter 4 as defining what organizations must do. This chapter defines what individuals can expect and, surprisingly, what's expected of them too. Let's dig in. Let's set the stage properly. Chapter 3 of the Act flips the lens we've used so far. Instead of asking, what must fiduciaries do, we're now asking, what can individuals actually demand and what must they do themselves? That second half often catches people completely off guard. I remember a workshop where a participant asked, almost indignantly, why would a privacy law impose duties on the very people it's supposed to protect? It's a fair question. Think about it this way though. Imagine a road safety law that only regulates drivers but says nothing about pedestrians jaywalking into traffic. Real safety requires responsibility flowing both directions. DPDP embraces that same philosophy. Individuals get meaningful rights, access, correction, erasure, grievance redressal, nomination, but they're also expected not to misuse those rights, say by filing false complaints or impersonating someone else's identity. Chapter 4 then handles special situations, cross-border data transfers, and specific exemptions when normal obligations don't fully apply. Together, these two chapters round out the individual-facing side of the Act, balancing what we studied in Chapter 4 about fiduciary obligations. Let's work through each provision with the same practical lens we've used throughout this course. Let's start with arguably the most foundational right under this chapter, the right to access information. Simply put, data principals can request a summary of what personal data a fiduciary holds about them, how it's being processed, and which other fiduciaries or processors it's been shared with. Think about why this right matters so fundamentally. You can't meaningfully exercise any other right, correction, erasure, grievance redressal, without first knowing what data exists and how it's being used. It's the foundation everything else stands on. Here's a real scenario I discuss often. Imagine applying for a loan and getting rejected, with the bank citing credit risk factors without specifics. Under this right, you could request exactly what data influenced that decision. Was it accurate income records or an outdated address linked to someone else's default history? That transparency genuinely matters. I worked with a telecom client building their access request response process, and their initial draft only showed customers their billing history, nothing about analytics profiles built from usage patterns. That's incomplete access, technically responsive, but missing the fuller picture the Act actually intends. So here's a question worth asking of any organization you work with. If a customer requested everything held about them today, could you actually produce a complete, accurate answer within a reasonable time frame? If that answer makes you uncomfortable, this right deserves serious operational attention. Now let's pair two closely related rights, correction and erasure. Correction lets individuals fix inaccurate or incomplete personal data. Erasure lets them request deletion once the original purpose for collection no longer applies, unless legal retention requirements override that request. Think of a practical example. Imagine your employer's HR system still lists your marital status as single 3 years after you got married, and that outdated field affects certain benefit calculations. Correction rights let you fix that directly, not just complain about it informally. Erasure gets more nuanced though. I worked with an e-commerce client who received an erasure request from a customer who'd made a purchase 18 months earlier. Should they delete everything immediately? Not quite. Tax and accounting laws required retaining transaction records for a specific period regardless of the individual's erasure request. That's the tension this section constantly navigates. Here's an analogy that helps clarify this balance. Think of erasure like requesting a library remove your name from a borrowing record. Reasonable once there's no ongoing need. But if that record is legally required for an active audit, the library can't simply comply immediately. Legal obligation temporarily overrides individual preference. So the real skill here isn't just building a delete button, it's building genuine judgment into your process, distinguishing requests that should be honored immediately from those requiring careful legal review first. Every right means little without a real mechanism to enforce it. And that's exactly what Section 13 provides, the right of grievance redressal. Data principals can complain directly to the fiduciary first, and if unsatisfied, escalate to the Data Protection Board. Here's a detail worth emphasizing. Fiduciaries must provide a readily available means for filing grievances and respond within a reasonable time frame. Think about apps that bury customer support behind endless chatbot loops with no human escalation path. That approach directly conflicts with this section's spirit. I recall a client whose only grievance channel was a generic info@ email address that took 3 weeks for any human response. When their DPO finally read this section carefully, they realized this simply wouldn't hold up if challenged. Reasonable time frame doesn't stretch to 3 weeks in most contexts. Think about grievance redressal like a hospital's emergency department versus its general reception desk. Not every complaint needs escalation to the board immediately, but organizations need a genuinely functional first line, one that actually resolves issues rather than deflecting them indefinitely. Here's a practical question worth asking. If a frustrated customer tried filing a genuine privacy grievance with your organization today, would they find a clear, responsive path, or would they hit a wall of automated responses and dead-end contact forms? That experience itself is what this section is designed to fix. Here's a right that surprises many people the first time they encounter it: the right to nominate. Data principals can nominate another individual to exercise their rights on their behalf in the event of death or incapacity. Think of it almost like a digital will, specifically for your personal data rights. Why does this matter practically? Consider someone managing an elderly parent's digital banking or healthcare accounts after they've become incapacitated. Without formal nomination, that adult child might struggle to exercise even basic rights, access, correction on their parents' behalf, facing bureaucratic resistance at every step. I discussed this provision with a fintech client building their customer account settings, and their initial reaction was, "Do we really need to build this now? It seems like an edge case." But think about scale. Across millions of users, incapacity and death aren't edge cases at all. They are statistical certainties over time. Here's a comparison worth noting. Most global privacy laws don't include anything quite like this nomination right. It's a genuinely India-specific innovation reflecting family-oriented realities where adult children often manage aging parents' affairs directly. So if you're designing account settings for any consumer platform, ask yourself, is there a clear, discoverable way for users to nominate someone for exactly this scenario? If not, you're missing a right the Act explicitly requires you to support. Now here's the section that genuinely surprises people trained on other privacy frameworks. Section 15, duties imposed on data principals themselves. Remember that jaywalking analogy from earlier? This is where it becomes concrete law rather than just a teaching metaphor. Specific duties include not impersonating another person while providing personal data, not suppressing material information when required, not filing false or frivolous grievances or complaints, and providing only verifiably authentic information when exercising rights under this Act. Think about a real scenario. Someone files repeated, baseless complaints against a company purely to harass them or extract settlement money without any genuine privacy violation occurring. Section 15 exists precisely to discourage exactly that kind of bad faith behavior, protecting fiduciaries from weaponized misuse of the Act's own protections. I remember explaining this to a client's legal team who initially assumed only businesses faced accountability under DPDP. Their relief was almost visible once they understood individuals face consequences too for genuine bad faith conduct, not just organizations. Here's the balance worth appreciating. This section doesn't diminish individual rights, it simply ensures those rights aren't weaponized dishonestly. Think of it as maintaining mutual good faith, rights and responsibilities flowing in both directions, exactly the balance we discussed at the start of this chapter. Let's address a question that comes up constantly in global business contexts. Can personal data collected in India be processed or transferred outside the country? Section 16 addresses cross-border data transfer, and here's what surprises many professionals. DPDP takes a notably more permissive approach than GDPR's complex adequacy mechanism. The default position allows transfers to any country except those specifically restricted by the central government through notification. Think about how different this is from GDPR's approach, which requires demonstrating adequacy, standard contractual clauses, or binding corporate rules for every single transfer outside the EU. I worked with a cloud services client anxious about their multi-region data architecture, servers spanning Singapore, Ireland, and the US. Their immediate assumption was, we'll need GDPR-style transfer mechanisms for every jurisdiction. Under DPDP's current approach, that's simply not the case, unless their specific destination country appears on a future restricted list. Here's the nuance worth remembering though. This permissive default doesn't mean transfers are unregulated entirely. Sector-specific rules, remember RBI's payment data localization requirement from Chapter 2, can still impose stricter requirements regardless of DPDP's general permissiveness. The two layers operate simultaneously. Think of it like international travel. DPDP sets a generally open border policy, but specific sectors might still require additional visas or restrictions layered on top. So the real question for any cross-border operation isn't just, does DPDP allow this? It's, does DPDP allow this, and do any sector-specific rules add further restrictions? Finally, let's cover situations where DPDP's obligations don't fully apply. Section 17's exemptions. These aren't loopholes for convenience. They're carefully scoped carve-outs for specific public interest situations, investigation of offenses, national security, research and statistical purposes, and certain government functions. Here's an example that illustrates the logic well. Imagine law enforcement investigating a serious cybercrime, tracing digital financial fraud across multiple platforms. Should investigators need explicit consent from a suspect before processing data relevant to that investigation? Obviously, that would defeat the entire purpose of law enforcement. I discussed this with a research institution client analyzing anonymized health data for public policy studies. Their compliance team initially assumed full consent requirements applied to every dataset they touched. Once we walked through Section 17, they recognized certain research activities, properly safeguarded and appropriately anonymized, qualified for exemption treatment. Here's an important caution though. These exemptions are narrow and specific, not a general escape hatch. I've seen organizations attempt to stretch research purposes to cover what was really just product analytics dressed up in academic language. That's exactly the kind of overreach regulators scrutinize closely. So here's the discipline worth building. Before claiming any exemption under Section 17, ask honestly, does this activity genuinely fall within the Act's specific listed categories with appropriate safeguards in place? Or is this an attempt to sidestep obligations that should otherwise apply? That honest self-assessment protects your organization far more reliably than aggressive interpretation. Let's bring Chapter 5 together. We explored the individual-facing rights that give DPDP real teeth, the right to access information as the foundation everything else builds on, correction and erasure balanced carefully against legal retention needs, grievance redressal as the enforcement mechanism that makes rights meaningful in practice, and the uniquely Indian right to nominate, reflecting family-oriented realities around incapacity and death. We also covered something many privacy professionals find genuinely surprising: Section 15's duties imposed on data principals themselves, ensuring good faith flows in both directions, not just from organizations toward individuals. Finally, we examined Section 16's notably permissive approach to cross-border data transfers and Section 17's narrow, carefully scoped exemptions for law enforcement, national security, and research purposes. Together, these provisions round out the individual side of DPDP, balancing everything we learnt about fiduciary obligations back in Chapter 4. If you want the fully structured version of this journey, complete with role plays, scenario-based quizzes, and practice tests, check out our complete course, DPDP Act Compliance Masterclass on Udemy, linked in the description below. Also, subscribe so you don't miss what's coming next, and click on the DPDP Act Master Series playlist in the description for the complete sequence. Next up, we turn to the body that actually enforces this entire act, the Data Protection Board of India. See you there.